All right, deep divers. Let's talk about medical legal reports. Whether you're dealing with a workers' comp case right now,
Yeah.
or maybe you're just curious about this kind of niche but super important part of the legal world, this deep dive is for you. Because these reports, they're not just your typical, like, doctor's visit summaries, they're the vital link
Hmm.
between your injury and the legal system.
Yeah, what's fascinating here is that these reports actually have the power to make or break your case. They're read by judges, disability raters, lawyers, a whole bunch of people who aren't medical professionals, but who are making decisions that have a huge impact on your life.
So basically, these reports have to tell a story, a really compelling and accurate story that someone with zero medical knowledge can understand. No pressure.
Right? Exactly. And that's why we're going to break down the must-haves of a strong report. We've got
Yeah.
some real-world examples of what not to do, sprinkled with some juicy insider tips from a disability rater. Plus, we're unpacking a chapter straight from a workers' comp handbook, so get ready to dive deep.
Okay, so first things first. What exactly is a medical legal report? And why should we care so much about getting it right?
So think of it as a specialized document. That translates your medical condition into legal terms. It's really the cornerstone of your workers' comp case because it establishes that connection between your injury and your work, the extent of your disability, and what kind of treatment and benefits you might be entitled to.
So it's not just about listing your symptoms, it's about creating this narrative that convinces the legal system that your injury is legit work-related and deserves compensation.
Precisely. And that narrative needs to be clear, concise, and compelling. It's got to walk that fine line between medical accuracy and legal clarity.
Okay, I'm starting to see why getting this report right is so important. So let's break it down. What are the building blocks of a solid medical legal report?
Well, our workers' comp handbook outlines all the essential components, and believe me, it's quite a list.
Don't worry, deep divers. We'll guide you through it step by step. So let's start with the basics. Identifying information. I'm guessing this is pretty straightforward.
You'd think so, but you'd be surprised how often errors here can cause major headaches down the line, getting the names, dates, claim numbers, addresses right from the get-go. That is crucial. It's like laying a solid foundation for your whole case.
Okay, so triple check those details, no typos allowed. What's next?
Next up is the opening statement, kind of like your report's first impression. Sets the stage by outlining the purpose of the report, date and location of the exam, and the all-important face-to-face time the doctor spent with you.
Face-to-face time. Is there a specific time requirement for that?
Absolutely. There are minimum minutes required depending on the type of exam. For example, a standard evaluation might need at least 20 minutes of direct interaction between you and the doctor.
Wait, so sitting in the waiting room doesn't count toward that time?
Nope. And this is where it gets interesting. Our disability rater friend spilled the tea on this one. Apparently, some doctors try to inflate this face-to-face time to make their reports look more thorough.
Wow, so it's not just about how much time you spend in the doctor's office, but about how much quality interaction you actually get. I'm guessing that's something disability raters pay close attention to.
You bet they're trained to spot inconsistencies and red flags, so honesty is always the best policy.
Okay, after the opening statement, what comes next?
Sources. And I'm not talking about gossip magazines. This is where meticulous documentation is key. Every single record, every conversation, every piece of information the doctor relied on to form their opinion needs to be listed.
So it's kind of like building a case file for your injury, with a clear paper trail to support the doctor's conclusions.
Think of it as creating a fortress of evidence to protect your claim. A thorough list of sources shows that the report is based on solid ground, not just the doctor's opinion pulled out of thin air.
Okay, so we've got the identifying info, the opening statement, and the sources. What comes next?
Now we get to the heart of the report, the history of your injury or illness.
This is where we get to tell our story, right?
Exactly. But remember, this isn't just a casual retelling of what happened. The level of detail here is crucial. We're talking specifics.
So instead of just saying, I hurt my back lifting boxes, I need to describe like the weight of the boxes, how often I was lifting them, the specific movements involved, maybe even the awkward position I was in.
Exactly. Paint a vivid picture for the reader. If it's a repetitive strain injury, you need a breakdown of your entire work history, showing how those repeated motions over time led to your condition.
Wow, that's a lot more detailed than I imagined. But I can see how it would paint a much clearer picture for someone who wasn't there.
Precisely, the more specific you are, the stronger your case becomes.
Okay, so after we've laid out the history of the injury, what comes next?
Well, now it's time to talk about how that injury is affecting your life right now. We call this the present complaints section.
So it's not just about the pain. but about the functional limitations, right? What can't you do at all? What's difficult or painful?
Exactly. And this is where honesty is key. Overstating your limitations can actually backfire and damage your credibility.
It's all about finding that balance between accurately representing the impact of the injury without exaggerating.
Precisely. And after we've covered the present complaints, it's time to delve into your overall medical history.
So any previous injuries, pre-existing conditions, other health issues, it all goes in here.
Yes, this section provides context for your current injury. For example, a previous back injury could make your current back pain more severe or harder to treat. It also helps address whether the work incident aggravated any pre-existing conditions.
Right, like if you had a wonky knee and then re-injured your back at work, this section would explain how those two things might be connected.
Exactly. It's about painting a complete picture of your health to show how the work injury fits into the bigger picture.
Okay, so we've covered the history, the current complaints, and the overall medical picture. What's next in our medical legal report adventure?
Well, after gathering all that information, the doctor will conduct their examination, and the findings from that exam need to be documented in plain English.
Plain English, why is that so important? Doctors love their medical jargon.
Remember, this report is going to be read by people who aren't medical professionals. Judges, lawyers, disability raters. They need to be able to understand it.
So instead of just listing a bunch of fancy medical tests, the report should explain what those tests were looking for and what they revealed about the injury.
Exactly. Think of it as translating the medical mumbo-jumbo into something everyone can understand.
I like it. Clear and concise communication is key. So after the examination findings, what's next?
The diagnosis, the moment of truth, where the doctor puts a name to your injury.
This must be a pretty straightforward section, right?
It should be. But clarity is crucial. The diagnosis needs to be specific and leave no room for ambiguity. It's the foundation for everything that follows.
Okay, so we got the history, the current complaints, other medical info, the exam findings, and the diagnosis. This report is starting to feel like a novel.
Don't worry, we're getting there. The next crucial piece is establishing the cause of the injury and how the work contributed to it.
This is where we separate the slip in the shower from the slip on a wet floor at work.
You got it. And it's especially important in cases of cumulative trauma or occupational illnesses. The report needs to demonstrate how your work activities or exposures over time led to your condition.
So if I'm a construction worker who developed carpal tunnel syndrome, the report would need to clearly link that condition to the repetitive motions I performed on the job.
Exactly. And remember, the work doesn't have to be the sole cause of your injury. It can be a contributing factor or even aggravate a pre-existing condition.
Right, like our earlier example of the wonky knee leading to back pain. That pre-existing condition could be made worse by the demands of the job.
Exactly. And the report needs to address that relationship clearly. For example, if you had a previous back injury and then re-injured your back at work, the report would need to explain how the work incident worsened your pre-existing condition.
So the cause of the injury section is all about making that connection between the work and the injury crystal clear, whether it's a direct cause, a contributing factor, or an aggravation of a pre-existing condition. Okay, what comes after that crucial link has been made?
Well, once the cause has been established, the report needs to address whether your condition has stabilized. This is what we call permanent and stationary status.
Permanent and stationary. That sounds a bit intimidating. What exactly does that mean? Does it mean I'll never get better?
It's not as scary as it sounds. Think of it this way. If you have a broken leg, the doctor will set the bone, put you in a cast, and over time the bone will heal. At some point, your leg will be as good as it's going to get. It's reached its maximum medical improvement. That's kind of like permanent and stationary status.
So it's like a plateau in the recovery process.
Yeah.
It doesn't necessarily mean I'm 100% healed, but it means I'm not likely to improve significantly with further treatment.
That's a great way to put it. And the physician needs to clearly state their opinion on whether you've reached this permanent and stationary status, along with the reasons for their conclusion.
And I imagine this determination is especially important for cases involving permanent disability benefits.
Yeah.
Right?
You are absolutely right. It's a key factor in determining what level of benefits you might be entitled to. But here's the thing. Even if a condition is considered permanent and stationary, it doesn't necessarily mean you won't need ongoing medical care. That's where the next section comes in.
Okay, I'm intrigued. Tell me more about this ongoing care, especially if the condition is supposedly permanent.
Well, think of it this way. Let's say you have a chronic back condition. Even though it might not improve significantly with more treatment, You might still need ongoing physical therapy or medication to manage your pain and keep things from getting worse.
Ah, I see. So permanent and stationary doesn't mean you're cured or pain-free. It just means you've reached a plateau in the healing process.
Exactly. And that's why the section on future medical treatment is so important. It lays out your anticipated needs even after your condition has stabilized.
Okay, so we've talked about establishing the cause of the injury
Hmm.
and determining whether the condition is permanent and stationary. What comes next?
Now things get a bit more technical. We move into a section dedicated to outlining the factors of disability, specifically for injuries that fall under the older permanent disability rating schedule.
Factors of disability. Okay. Deep divers, get ready for some serious unpacking. What kind of factors are we talking about here?
Essentially, this section breaks down your disability into different categories to paint a comprehensive picture of how your injury impacts your life. First up, we have the subjective factors, which are all about how you personally experience the limitations caused by your injury.
So this is where things like pain, stiffness, fatigue, difficulty sleeping come into play.
Exactly. It's about how the injury affects your daily life, your ability to work, and your overall well-being.
And I'm guessing this is where it's crucial to be honest and accurate in describing those limitations to your doctor.
Absolutely. The doctor needs a clear understanding of how the injury is impacting you personally.
Okay, so we've covered the subjective side of things. What about the objective factors?
These are the measurable things, like restricted range of motion, loss of strength, or atrophy, things that can be observed and documented during the medical exam.
So if I injured my shoulder and can't lift my arm as high as I used to, that would be an objective factor.
Precisely, and the report needs to clearly document those limitations, often using specific measurements like degrees of motion or strength ratings.
Okay, so we've got subjective and objective factors covered. What other pieces of the puzzle are we missing?
After the subjective and objective factors, we move on to work restrictions. This is where we start connecting the dots between your injury and your ability to perform your job.
Work restrictions. I've heard a lot about those, but I'm not entirely sure what they mean in practice.
It's actually quite straightforward. Work restrictions are limitations on the types of activities you can safely perform. They're designed to prevent further injury or aggravation of your existing condition.
So if someone injured their back lifting heavy objects, a work restriction might limit how much weight they can lift or how often they can lift it.
Exactly. And work restrictions can also address things like posture, repetitive motions, or even exposure to certain environments. The key is to identify both what you can't do and what you should avoid to prevent further harm.
This sounds like a crucial piece of the puzzle, especially when it comes to determining a worker's ability to return to work.
You are absolutely right. And it leads directly into the next factor, the estimation of loss of capacity. This is where things get really interesting.
Okay, estimation of loss of capacity. Break that down for me. What exactly does that mean?
It's all about assessing how much the injury has affected your ability to work. It takes into account all the factors we've discussed so far, the subjective limitations, the objective findings, and the work restrictions, and translates them into a percentage.
So if my doctor determines that due to my injury, I've lost 50% of my ability to perform my previous job, that would be my estimated loss of capacity.
That's the general idea, and this percentage is a key factor in determining the level of permanent disability benefits you might be entitled to.
Wow, so this section really is the big one. It takes all the pieces of the puzzle and puts them together to determine the impact of the injury on a worker's ability to earn a living.
You got it, and it requires a careful and thorough analysis from the physician, taking into account all the nuances of your case.
Okay, we've covered the subjective factors, the objective factors, work restrictions, and the estimation of loss of capacity. Are there any other factors of disability we need to discuss?
Yes, one more, and it's a big one, especially when pre-existing conditions are involved, the apportionment of disability.
Apportionment. Okay, that sounds complicated. Give me the ELI-5 version.
Imagine you have a cake, and you need to divide it between two people based on how much they contributed to baking it. Apportionment is kind of like that. It's about dividing responsibility for the disability between the work injury and any pre-existing conditions you might have.
So if I had a pre-existing back problem and then injured my back further at work, apportionment would determine how much of my current disability is due to the work injury versus the pre-existing condition.
Exactly. It's about separating out the impact of the work injury from any other factors that might be contributing to your disability.
And I imagine this can have a significant impact on the benefits a worker receives.
Absolutely. Apportionment only applies to permanent disability, not to treatment or temporary benefits. but it can significantly impact the amount of permanent disability benefits you might receive.
So it's a crucial piece of the puzzle, especially when pre-existing conditions are involved. Okay, we've covered the apportionment of disability. What's next in our medical legal report deep dive?
Well, after all those factors of disability have been addressed, the report needs to outline the medical treatment that's indicated for your condition.
So this is where the doctor lays out a treatment plan, recommending specific interventions to address the injury.
Precisely, it may include things like medication, physical therapy, injections, surgery, or any other treatment deemed necessary to cure or relieve the effects of the injury.
And this section isn't just about the immediate needs, right? It also looks ahead to the future.
You are absolutely correct. There's a separate section dedicated to outlining the need for future medical treatment. Even if your condition is considered permanent and stationary?
Hold on. I thought permanent and stationary meant the condition wouldn't improve. Why would future treatment be needed?
Great question. Even if a condition has stabilized, it doesn't mean that further treatment won't be necessary. To maintain your condition, prevent further deterioration, or address any reasonably anticipated future problems.
So if someone has a chronic back condition, they might need ongoing physical therapy or medication to manage their pain and prevent flare-ups.
Exactly. It's about thinking long-term and making sure you have access to the care you need down the line.
So the report addresses both the current treatment needs and the potential need for future treatment. What comes after that?
Well, after all those recommendations, the report needs to clearly explain the reasons behind all the opinions and conclusions that have been reached.
So it's not enough to just state an opinion. The doctor needs to back it up with evidence and reasoning.
Exactly. This is where the physician's expertise shines through. They need to clearly articulate the why behind their diagnosis, their assessment of disability, and their treatment recommendations.
This makes sense. It's about providing transparency and showing that the conclusions are based on sound medical judgment, not just pulled out of a hat.
Precisely. And this section is crucial for building credibility and ensuring that the report can stand up to scrutiny.
So the reasons for the opinion section is all about providing the rationale behind the doctor's professional assessment. What's next on our checklist for a comprehensive medical legal report?
Well, in the spirit of transparency, the report also needs to disclose the names and qualifications of any other individuals who were involved in the evaluation process.
So if the physician had an assistant who helped with taking the medical history or administering diagnostic tests, their information needs to be included.
Exactly. It's all about being upfront about who contributed to the report and what their role was. Transparency is key.
This makes sense. It ensures that everyone involved in the evaluation process is accountable for their contributions. Okay, so we've covered the reasoning behind the opinions and the disclosure of other individuals involved. What's left?
Well, there are a few more formalities that are essential for the report to be considered valid.
Formalities. I'm all ears. What do we need to know about these legal must-haves?
First up, we have the mandatory declaration. It's a legal statement required by law that the information in the report is true and correct, to the best of the physician's knowledge and belief.
So it's like swearing an oath on the accuracy of the report.
That's a great way to put it. It adds a layer of legal weight to the document and shows that the doctor is taking their responsibilities seriously.
Okay, I can see how that would be important in a legal setting. What else do we need to know about these formalities?
Well, after the mandatory declaration, we have the signature. And this isn't just any old signature. It needs to be the original signature of the physician who prepared the report.
So no digital signatures or stamps allowed?
Nope. The original signature signifies that the doctor personally stands behind their assessment and is willing to attest to its accuracy.
That definitely adds a level of seriousness and accountability to the document. Are there any other formalities we need to address?
Yes, one more. The report also needs to include a disclosure of any significant beneficial interest the physician might have.
Beneficial interest?
Yeah.
What does that mean in this context?
Essentially, it's about ensuring there's no conflict of interest. For example, if the doctor has ownership in a lab or clinic that they referred you to, that information needs to be disclosed.
Ah, I see. It's all about transparency and making sure the doctor's recommendations are based solely on your best interests, not on any potential financial gain.
Exactly. It's about keeping things ethical and above board.
Okay, we've covered the mandatory declaration, the signature, and the disclosure of any beneficial interests. Have we finally reached the end of our checklist for a comprehensive medical legal report?
We're almost there. There are a few more forms that need to be attached to the report, depending on the specifics of your case. For example, a copy of the summary form needs to be included, and you might also need to fill out a questionnaire or a request for disability rating, it's best to check with your doctor or lawyer to make sure you have all the necessary paperwork.
So it's like a package deal. The report itself, plus these essential forms. And without these forms, the process could get held up.
Exactly. It's crucial to make sure all the paperwork is in order to avoid delays. Okay, so we've covered all the essential components of a strong medical legal report. But there's one more thing we need to discuss, and it's a big one. Timeliness.
Ah, yes, deadlines. I have a love-hate relationship with those. How much time does the doctor have to get this report done?
The deadline depends on the day of your injury. For most cases, the report must be submitted within 30 days of the evaluation.
30 days. That's not a lot of time to put together such a detailed and comprehensive document. What happens if the doctor misses the deadline?
Well, there are potential extensions available, but they need to be requested in advance and approved for a valid reason, like waiting on test results. It's not just a matter of asking for more time whenever you feel like it.
So timeliness is key. But we can't wrap up this part of our deep dive without talking about the elephant in the room, payment. Who foots the bill for these reports?
That would be the employer.
The employer. So even though the report is about the worker's injury, it's the employer who has to pay for it.
That's how it works in the workers' compensation system. And there are specific rules regarding the timing and method of payment.
Okay, I'm all ears. Tell me more about these payment rules. What are the deadlines?
The employer typically has 60 days to pay for the medical legal expenses after receiving the bill and the report. But here's the catch. If the payment is delayed, the employer faces some hefty penalties, including a 10% increase plus 7% interest per year.
Wow, that's a serious incentive to pay those bills on time. I'm guessing those penalties help keep things moving along. Is there anything else we need to know about the payment process before we move on?
Just one more thing. The medical legal fee schedule dictates how much doctors can charge for these reports. And to avoid payment delays, the doctor should clearly document how they arrived at their billed amount, providing a breakdown of the hours spent, or the specific elements included in the report.
So it's not just about submitting the report. It's about justifying those fees with clear documentation. Transparency is key.
Exactly. Clear communication throughout the process is essential, from the initial evaluation to the final payment.
Well, deep divers, I think we've covered a lot of ground today, just in this first part. We've explored the essential components of a medical legal report, from the identifying information to the payment process.
We'll be back soon with the second part of our deep dive, where we'll explore some juicy insider tips from our disability rater friend and delve into some real-world examples of what not to do when it comes to medical legal reports. Stay tuned.
Welcome back, deep divers. Ready to unearth some more nuggets of wisdom about medical legal reports? You bet. In the last part, we kind of laid the groundwork going through all the essential pieces of the report, but I have a feeling things are about to get even more interesting.
You're right about that. Now we're going to delve into some real-world examples of what not to do. Remember those insider tips from our disability rater friend?
Oh, yeah. They mentioned how untimeliness, jargon, incomplete evaluations, inconsistencies can make a report practically useless.
Exactly. And these issues can have real consequences for you. If a report is unclear, inconsistent, or doesn't address the key legal questions, it can delay your case, lead to an inaccurate disability rating, or even result in you being denied benefit.
Okay, now I'm really paying attention. So where can we find these examples of medical legal report fails? I'm ready for some cautionary tales.
Well, our trusty Workers' Comp Handbook has a whole section dedicated to this, aptly titled Excerpts from Inadequate Reports.
Let's dive in. What's the first example?
This one deals with work restrictions. The report says, I would preclude any heavy lifting or prolonged repetitive activities with her right upper extremity and any gripping with her right hand.
That seems pretty straightforward to me. What's wrong with that?
On the surface, it might seem clear, but remember what our disability rater friend emphasized. Specificity is key. Those restrictions are way too vague.
Ah, I see what you mean. Instead of just saying heavy lifting, the report should specify exactly how much weight can be lifted safely. And instead of prolonged repetitive activities, it should outline the specific motions that need to be limited.
Exactly. These reports are used to make decisions about your job suitability and your disability rating. The more specific the restrictions, the better those decisions will be.
So vague restrictions could end up hurting me in the long run, even if they sound okay at first glance.
Precisely. Let's move on to another example, this time focusing on the degree of disability. The report states, the left foot complaints preclude him from prolonged weight-bearing activities and limit him to semi-sedentary work. However, This does not affect such things as stooping or bending or lifting capability, and the raters should take this into account when considering his overall working capacity. The left knee and low back complaints appear to represent minimal hindrance to his activity and would not add significantly to his disability level.
Whoa, that's a mouthful. What's the problem here?
This one's a classic example of internal inconsistency. The report says the worker can't do prolonged weight bearing, but then claims it doesn't affect their lifting capability. That just doesn't make sense.
You're right. If you can't stand or walk for long periods,
Yeah.
it's going to affect your ability to lift things.
Exactly. These inconsistencies raise red flags for disability raters. They're left wondering if the physician truly understands the extent of your limitations.
And if they question one part of the report, they might start questioning everything else.
Yeah. Exactly. It's like a crack in the foundation. It weakens the entire structure.
Okay, this is eye-opening. Inconsistency is definitely something to watch out for. What's our next example?
This one is about future medical treatment, and it highlights a missed opportunity to really advocate for your needs. The report says, as was stated previously, based on present findings on examination, there is no clinical indication to warrant any further diagnostic studies or active treatment, other than on a simple supportive and symptomatic basis. It is felt, however, that based on symptoms over this period of time of some 6 years, and with the pathology as noted from the previous arthroscopic procedures performed, medical care should be afforded to him in the future with any settlement in the event that his symptoms do progress or become intolerable, where he would need a more active treatment program, including the possibility of further surgery.
Okay, my head is spinning a bit. I'm getting lost in all those words. What's the key takeaway here?
The report mentions the possibility of future surgery, but in a very vague and unhelpful way. Remember, specificity is key, especially when it comes to your future medical needs.
So instead of just saying the possibility of further surgery, the report should outline what kind of surgery might be needed, how likely it is, and what the recovery process would entail.
Precisely. It's about providing a clear roadmap for the future, not just throwing out vague possibilities. This section can have a huge impact on your ability to access the care you need down the line. So it's crucial that it's as detailed and specific as possible.
Okay, I'm starting to see a pattern here. Specificity, clarity, and consistency are the golden rules when it comes to writing effective medical legal reports. It seems like every detail matters.
You're absolutely right. Now let's look at one final example, this time dealing with the discussion section. It says, the patient sustained a serious injury on January 17, 1992. It is very likely that he has had subclinical psoriatic arthritis for a long time prior to the injury. It is very possible for the psoriatic arthritis to precipitate as a result of trauma. In consideration of the patient's overall medical condition, it is reasonable to assume that the patient has reached the permanent and stationary status. The objective factors and the patient's disability rating are very minimal, perhaps less than 5% of the right upper extremity. The subjective complaint plays a significant role in the range of about 10% of the right upper extremity. However, there is a contributing factor, which is his psoriatic arthritis and history of his gout. I would estimate that 20% of his disability is contributed by the underlying medical problem and 80% by the injury itself.
Okay, this one brings us back to the idea of apportionment, right? Dividing responsibility for the disability between the work injury and pre-existing conditions.
Exactly. But this example highlights a common mistake doctors make when it comes to apportionment. Remember, you can only apportion to a pre-existing condition if it would have caused permanent disability on its own, even without the work injury.
So in this example, the doctor is suggesting that 20% of the disability is due to the pre-existing psoriatic arthritis. What's wrong with that? It seems like they're acknowledging the pre-existing condition and trying to be fair.
The problem is that they haven't shown that the psoriatic arthritis would have caused any disability on its own, independent of the work injury. They're essentially apportioning to a condition that might have been completely asymptomatic before the incident.
Ah, I see. So you can't just point to any pre-existing condition and say it's partly responsible for the disability. You have to prove that it would have caused a measurable level of disability, even without the work injury.
Exactly. Apportionment needs to be based on solid medical evidence, not just assumptions or speculation.
These examples are really helpful. I'm starting to understand the level of detail and precision required in these reports. It seems like every detail matters. But what happens when a report is deemed inadequate? Does it just get thrown out?
Not exactly. Our handbook actually provides a glimpse into what happens with these flawed reports.
Okay, walk me through it.
There's a section that shows an evaluation of a medical legal report. Think of it like a report card for the report itself. The evaluator checks boxes indicating why the report couldn't be used for a disability rating. They might say the report failed to provide adequate information on the factors of disability, failed to address the necessary legal issues, or was internally inconsistent.
So if the report gets a failing grade, what happens next?
In most cases, the report is sent back to the doctor for revisions. They have to go back and fix the errors, provide more information, or clarify their conclusions.
Wow, that sounds like a major headache for everyone involved.
Yeah.
Especially for you, the injured worker. It just highlights how important it is to have a strong report from the get-go.
Absolutely. A poorly written report can lead to significant delays, which can be incredibly frustrating when you're trying to access the benefits you need. It's crucial to remember that the medical legal report is your advocate. It's the document that speaks for you in the workers' comp system.
Okay, so we've seen some cautionary tales and learned about the consequences of inadequate reports. What else do we need to know about this evaluation process?
Well, there's one final detail that might seem minor, but it's actually crucial for the report's validity, the disclosure of everyone involved in its creation.
Right. We talked about transparency earlier, listing everyone who contributed to the evaluation and their qualifications. Why is that so important again?
It's about ensuring that the report was created according to California law, which is very strict about who can be involved. The doctor who signs the report must be the only one who examines you or participates in the non-clerical preparation of the report.
So a nurse can take my vitals,
Yeah.
but they can't summarize my medical history for the doctor.
Exactly. The physician needs to personally review all the information and form their own independent conclusions.
Now, that's a lot stricter than I imagined. What happens if someone else contributes to the report without being disclosed?
There can be serious consequences, including the physician being suspended or even terminated as a qualified medical evaluator.
So it's not just about ethics, it's about following the letter of the law. Transparency and accountability are paramount in this process. Okay, so we've covered who can and can't be involved in the report. Any other surprises about this disclosure rule?
Actually, there is one interesting exception, the transcriptionist.
The transcriptionist.
Yeah.
The person who types up the doctor's notes. Why are they exempt from the disclosure rule?
It's a bit of mystery, but the law specifically states that the name of the transcriptionist doesn't need to be included in the report.
That's strange. It seems like a random loophole.
It does, doesn't it? But regardless of the reason, it's important to be aware of this exception to the rule. So make sure the names and qualifications of everyone else involved in the report are clearly stated, except for the stealthy transcriptionist working behind the scenes.
Got it. Don't forget anyone except the mysterious transcriber. Okay, I think I'm getting a much better handle on this whole medical legal report thing. We've covered the essential components, the common mistakes, the importance of transparency, and even the role of the disability rater. What else is there to explore?
Well, there's still more to uncover. In the final part of our deep dive, we'll delve into the concept of permanent and stationary status in more detail and uncover some practical tips for navigating the world of medical legal reports. Stay tuned.
Welcome back, deep divers. We're about to surface from our deep dive into medical legal reports, but we still got some fascinating territory to explore. In the last part, we uncovered some common mistakes and got some insider tips from our disability rater friend.
Right, we saw how seemingly minor errors can have a big impact on your case, and how important it is to have a report that's clear, concise, and consistent.
Exactly. Now, before we wrap things up, I want to circle back to a concept we touched on earlier. Permanent and stationary status. It's a crucial piece of the puzzle, and I think it deserves a bit more attention.
I agree, it's a concept that often causes confusion, so let's break it down further. Remember, permanent and stationary essentially means that your condition has stabilized and isn't expected to improve significantly with further medical treatment.
Right. It's like reaching a plateau in the recovery process. But what I still don't quite grasp is why you would need ongoing medical care. If your condition isn't going to get better, it seems a bit counterintuitive.
That's a great point, and it's where a lot of people get tripped up. You see, permanent and stationary doesn't mean your condition is cured or that you're suddenly pain-free. It simply means that further improvement is unlikely. So even if a condition has stabilized, you might still need treatment to manage your pain, prevent things from getting worse, or address any potential problems down the line.
Exactly. Let's say you have a herniated disc in your back. Your doctor might determine that your condition is permanent and stationary, meaning it's not going to magically heal itself. But you might still need ongoing physical therapy to strengthen your back muscles, medication to manage pain flare-ups, or even injections to reduce inflammation.
That makes much more sense. It's about maintaining the best possible quality of life, even if a complete recovery isn't realistic.
Precisely. And that's why the future medical treatment section in a medical legal report is so crucial. It outlines those anticipated needs, ensuring you have access to the care you might require in the years to come.
Okay, so permanent and stationary isn't a death sentence for your health. It's more like a reality check. It's about adapting to your condition and finding ways to manage it effectively. That's a great way to put it. Now let's shift gears a bit and talk about another key player in this whole process, the disability rater. We've mentioned them throughout our deep dive, but I think it's time to give them their moment in the spotlight.
Yes. Tell me more about these mysterious disability raters. What exactly do they do, and why are they so important?
Disability raters are the unsung heroes of the workers' comp system. They take the physician's report along with other relevant information about your job and your limitations and use a complex formula to calculate your disability rating.
So they're like the translators between the medical world and the legal world.
That's a great analogy. They bridge the gap between the doctor's assessment and the actual benefits you receive.
And that disability rating, what does it actually tell us?
It's a percentage that reflects how much your injury has affected your ability to earn a living. It takes into account your age, your occupation, your education, and the severity of your limitations.
Wow, that's a lot to consider. They must need a deep understanding of both medicine and law to do their job effectively.
You're absolutely right. They need to be able to decipher medical jargon, understand the complexities of the workers' comp system, and have a keen sense of how different injuries can impact a person's ability to work.
I'm starting to see why having a clear, concise, and accurate medical legal report is so crucial. It's a foundation for the disability rater's assessment.
Exactly. If the report is confusing, inconsistent, or missing key information, it makes the disability rater's job that much harder, and it could lead to an inaccurate rating.
Okay, I think I'm finally getting the big picture here. The doctor report, the disability rater, the legal system. It's all interconnected. Each piece plays a vital role in ensuring you receive the benefits you deserve.
That's a great takeaway. And understanding these connections can empower you to be a more informed and proactive participant in your own case.
Well, deep divers, I think it's time to surface from our deep dive into the world of medical legal reports. We've explored the essential components, the potential pitfalls, the importance of timeliness and clarity, and the key roles played by the physician and the disability rater.
We've demystified this often intimidating topic and armed you with the knowledge to navigate the workers' comp system with confidence.
I know I'm feeling much more empowered, and I hope our listeners are too. Remember, knowledge is power, especially when it comes to advocating for your rights.
Absolutely. We encourage you to continue exploring this topic, ask questions, and be an active participant in your case.
And if you ever feel lost or overwhelmed, don't hesitate to seek guidance from a qualified professional. There are resources available to support you every step of the way.
Remember, you're not alone in this journey.
Well, deep divers, it's time for us to bid farewell. But don't let the exploration end here. Keep learning, keep questioning, and keep advocating for yourself. Until next time, stay curious and keep diving deep.